tak mati kan bila tu. Hello, Prof. Rahmat. Good afternoon.
Hello, Shafria. Good afternoon to you.
How are you?
I'm good, Alhamdulillah.
Alhamdulillah.
How
Glad
about
to
you?
hear that. Yeah, very fine and happy to see you.
Thank you. Thank you. Yes.
So, hello everyone. Thank you for joining us in our guest lecture today. On behalf of the Postgraduate School Alangga University, I would like to say to Professor Rahmat, thank you for your willingness to contribute to our school through this guest lecture. So before we start today's guest lecture with the topic of law and society development in Malaysia, please allow me to introduce our moderator, Dr. Radian Salman, who is a head coordinator of Science in Law and Development in Postgraduate School Alangga University. Without any further ado, Dr. Radian Salman, may you kindly say hi first? Pak Radian?
Test. Okay. Professor Ahmad, I'm still have problem with my camera.
Yeah.
I will fix in a second. Wait.
Please take your time. No problem.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, I think in Malaysia, or good evening. Selamat sore di Indonesia pada seluruh peserta international guest lecture. Ya. We have Professor Dato Rahmat Muhammad. He is a professor from UITM, Malaysia. I have his CV. Jadi saya punya CV-nya, tapi saya tidak ingin membacakan sangat panjang. Saya sudah bertemu beliau di UITM. Beliau pengalaman akademiknya sangat panjang, termasuk menjadi Vice Chancellor di UITM Malaysia. Beliau juga menjadi sekretaris kerjasama Asian Africa Organization. Jadi pengalaman internasional beliau sangat luas sekali. Dan currently beliau adalah Chairman Lembaga Institut Sukan Negara Malaysia. Apa itu? What is that? we don't know Professor Rahmat Muhammad. You may explain your institution. Yeah, Professor Rahmat, our participant here mostly a student in Master Science in Law and Development, postgraduate school of Airlangga University. So I would like to say that this is a unique study program in Airlangga in Indonesia also, because this is a multidisciplinary program. So this is not purely law. So the name of the program is Law and Development. So one of the course is Law and Society. So we request to have this topic because we have course, kita punya mata kuliah di Indonesia, di prodi ini, program studi ini, hukum dan masyarakat, law and society. So I think it will be relevant to have you as a professor of law with a lot of experience untuk menjelaskan law and society in Malaysia. Professor Rahmat, it depends on you, but I think it is better maybe you may use Melayu and also maybe English, because mostly we are the participant come from Indonesia. There will be still many participants will come. Kita para mahasiswa dan partisipan, we have 1 hour in total for this guest lecture. So maybe Professor Rahmat, you may give your lecture about 50 minutes, then we continue 10 minutes for discussion. Datuk Profesor Rahmat Muhammad, dipersilakan.
Terima kasih Dr. Radian. Ketemu lagi kita, tetapi secara cyber kali ini. I know that we have met a few years ago semasa saya menjadi dekan di fakultas, di Fakulti Law di UiTM. Jadi saya sangat gembira dapat ketemu kembali dengan Dr. Radian. Jadi saya mengucapkan banyak terima kasih kepada Postgraduate School kerana pertama melantik saya sebagai visiting professor di Airlangga University. Yang keduanya menjemput saya untuk memberikan kuliah kepada postgraduate di Universitas Airlangga. Saya ingin share skrin saya bersama-sama dengan para pelajar dan juga akademik di sana. Pertama sekali saya ingin menyatakan beberapa perkara tentang topik law and society development in Malaysia. Ia satu topik yang menarik, it is a very interesting topic to me. But as a professor of international law, saya ingin menceritakan hari ini impak bagaimana undang-undang ataupun hukum antarabangsa itu, international law itu, apabila diperkenalkan di peringkat negara ataupun the state, apakah impaknya kepada society ataupun masyarakat di situ, so I rather speak on or talk on the impact of domestication of international law on the law and society. I think this is very relevant untuk tujuan itu. Dan saya mulakan background ataupun latar belakang kepada kuliah saya ini, di mana ini this is very much experienced by Malaysia. Recently Malaysia has been pressured by certain international NGO, especially those NGO that promote human rights. They actually pressured Malaysia to ratify international treaties on human rights. Saya fikir ini pun berlaku juga di Indonesia, di mana sudah ada tekanan yang kuat di kalangan international community untuk negara-negara seperti Malaysia untuk menandatangani treaty-treaty yang berkaitan dengan human right. Di Malaysia buat pada masa ini hanya 2 saja yang kerajaan Malaysia atau pemerintah Malaysia sudah tanda tangani, iaitu satu berkaitan dengan wanita ataupun women, CEDAW. Yang keduanya ialah berkaitan dengan children, CEDAW and CRC. Of course, ada lain-lain lagi berkaitan dengan international human rights, umpamanya ICERT, racial discrimination, on torture dan sebagainya. Tetapi Malaysia hanya so far kita hanya ratify 2 saja. Of course, pada tahun 2019 Malaysia juga sudah ratify the Rome Statute of ICC, International Criminal Court. Tapi atas bantahan kuat daripada masyarakat di Malaysia, sayalah yang bertanggungjawab membawa memorandum kepada pemerintah untuk tidak menerima Rome Statute itu, dan kerajaan Malaysia pada ketika itu menarik diri, withdrew from being a signatory to the Rome Statute. Saya akan bincangkan mengapa berlaku perkara tersebut. Of course, tindakan kerajaan Malaysia itu tidak disukai ataupun was disappointed with many human rights organisation. Pada pendapat saya, my opinion is that before you become a signatory to any international treaties, you have to fulfill several conditions. Perlu memenuhi beberapa syarat yang penting, dan antaranya ialah apabila satu international instrument itu menyatakan tentang menjadikan international treaty itu sebagai sebahagian daripada undang-undang tempatan, atau national laws, it has to follow the procedures. The process must be followed. Bermakna perlu ada mungkin referendum untuk rakyat memberikan pandangan mereka, mungkin perlu satu transparansi bagaimana ia boleh diterima dan sebagainya. Sebab untuk menjadi signatory kepada international human right laws ini bukan satu yang mudah. Is very critical that the government will have to adhere to certain rules, dan especially the society. The society must be informed of the full impact sepenuhnya terhadap undang-undang yang akan menjadi undang-undang tempatan. Seumpamanya the Rome Statute of International Criminal Court, if it is going to be implemented in Malaysia, you have to rectify, you have to amend certain criminal laws, local criminal laws, so that it come together with the Rome Statute. Bermakna di Malaysia undang-undang jenayah ialah penal code, dan acara jenayah itu, penal code itu perlu meletakkan definisi baru seperti apakah itu genocide, pembunuhan secara genocide, pembunuhan secara crime against humanity, for example. Jadi ini tidak dilakukan at the national level. Kalau ini tidak dilakukan, if this is not done, if this is not amended, then it is not synchronized, it is not consistent with the Rome Statute, dan lain-lain yang lain. Jadi once it has become a national legislation, dibawa ke Parlimen untuk diluluskan sebagai akta ataupun undang-undang negara, these are things that need to be done. Umpamanya bila kita bercakap tentang Paris Climate Change Agreement, sama ada kerajaan kita atau pemerintah sudah berbincang atau berbicara dengan rakyat atau masyarakat tentang kepentingan climate change itu, apakah impactnya. Begitu juga dengan WTO. Kerana all these are very crucial issues, and the government play a crucial role, and they have to inform, and they have to be transparent to the society. di dalam when they want to embark or embrace this international convention or treaty. So that is my lecture today. I think I hope para pelajar postgraduate dapat menerimanya. Kalau ada apa-apa persoalan, sila boleh tanya saya di akhir sesi nanti. Jadi, if I may continue. So this is the changing paradigm of international law. I'll give you the big picture, the global picture. International law at one time is very much focused on just state sovereignty. What is empowered to the state? Yeah, it talks only about your territory. It talks about non-intervention. It talks about you are equal with other states. These are traditional structure of international law. But in the past decade, we witnessed the shift of the focus. Yeah, in other words, there is a transformation in international law, taking into account public goods and to fulfill community interest. Bermakna law and society melibatkan apabila keterlibatan undang-undang antarabangsa itu ataupun hukum antarabangsa itu sudah berbeza sekarang ini. Dia tidak mengikut secara tradisionalnya. They don't talk about now, of course, the classical international talk about territorial integrity, for example. But now it talks about public good and also community interest. So now there are a lot of changes in the making of international law. For example, climate change. Yeah. Now we are talking about equitable distribution of vaccination. You know, there is already a discussion in the United Nations General Assembly that the poor country must also be given the right to help. For example, the poor country can't afford to buy vaccination, but there is this pressure by international community to give that, the equitable right of poor countries to get to be vaccinated. So there is a change, there is a shift, or there is a transformation from the classical international law, which only talk about territorial integrity of a state, towards public goods, towards fulfillment of community interests. So this, if in fact, affect the law and society. And I think, a country cannot live alone. Ya, kita tidak keseorangan kerana the world is so interdependent, and because of globalization, that we, in a way, cannot simply dismiss the importance of international law, and how it interacts with our local community or our society. Yeah. So jadi bila kita bercakap pula berkaitan dengan public goods and the fulfillment of community interest, ada beberapa persoalan yang kita akan tertanya-tanya. For whose benefit is this public goods? Are we talking for real? For example, walaupun there is a resolution, walaupun sudah ada resolusi di United Nations General Assembly, sudah diterima oleh United Nations Security Council tentang fair and equitable distribution of vaccination, adakah itu berlaku sehingga kini? When we talk about world trade, fair trade, adakah itu berlaku di kalangan negara-negara membangun, developing and least developing countries? Then, if it is not happening, if it is not for the benefit of the society as a whole, because we have to look at the society in a global perspective, in a global context, there is always this argument between the developed world and developing and least developed countries. the north and south divide di antara utara dan selatan selalu bercakaran, tidak boleh terima satu resolusi saja. Jadi kalau if we are not benefiting out of this, if the society as a whole have not actually benefited from the treaties or conventions that they have designed or created, then how do we frame the instrument? Yeah, because we know the politics of international relations, the real politic, only those in power will have will dictate the destiny of the world. Yeah, for example, yeah, yang berlaku sekarang begitulah. Ya, Ukraine menjadi mangsa kepada perang jenayah dan sebagainya, dan NATO dan kuasa besar seperti United States hanya melihat dan memberikan weapon, tetapi yang hancur lebur dan banyak kerugian adalah rakyat itu, ya, rakyat sendiri, ya, atas perbuatan pemimpin-pemimpin mungkin. Jadi ini adalah antara ya, yang berlaku pada masa ini. Dan apabila kita hendak if we want to frame the international instrument, for example, should we take into consideration the sensitivity of religion, culture and custom? For example, if we talk about international human rights as regard to discrimination, racial discrimination, religion dan sebagainya, apakah we have to agree on LBGT, for example? Sedangkan agama Islam itu dan agama-agama besar tidak bersetuju tentang promosi LBGT itu, ya. Dan kita melihat now international organization or NGOs yang berteraskan kepada human rights nampaknya seolah-olah memberikan tekanan kepada kerajaan untuk menerima, ya, LBGT itu sebahagian daripada equal gender, equal right dan sebagainya. So should we take into consideration the sensitivity of religion, culture and custom? So this is where the clash, ya, that berlakunya clash antara negara-negara, ya. Dan apabila kita ditekankan untuk menerima sesuatu international treaties itu dijadikan sebahagian daripada undang-undang tempatan, mengapa pula superpowers seperti Amerika, China, India, ya, tidak menjadi ahli langsung kepada umpamanya Rome Statute of ICC? Jadi it leads to more questions. So we want to ask more questions. Because at the end of the day, ya, negara itu yang akan bertanggungjawab. Kerajaan dan pemerintah itu bertanggungjawab. Rakyat yang akan menerima impaknya. Ya, at the end of the day, kita sebagai rakyat, the society will have to take the burden or the impact will be on us. Ya. So itulah yang saya ingin. Jadi scope of discussion saya pada hari ini ialah issues, ya, apakah isu-isunya, challenges dan juga konklusi, ya. Jadi berkait rapat dengan law and society, ya, what are the impact? What impact does international law, particularly treaties and convention, have on our life? Yeah. For example, the World Trade Organization, WTO agreement. How does WTO shape our life, especially as consumer to the product of multinational companies, as opposed to the local product? Ya. Kerana di bawah WTO sudah ada satu regime, iaitu selain daripada WTO juga TRIP, ya, Trade Related Intellectual Property, yang sudah memberikan impak yang besar kepada negara-negara miskin, kepada pengguna-pengguna seperti kita, the society especially, ya. Kerana kita lihat Trade Related Intellectual Property itu hanya memberikan benefit kepada multinational companies, tidak kepada negara-negara miskin, negara-negara yang sedang membangun seperti kita. Baru-baru ini umpamanya WHO telah membuat usul kepada United Nations, ya, bangsa-bangsa bersatu, supaya jangan mengenakan intellectual property kepada ya, apabila hendak membuat distribution vaccination umpamanya, ataupun jika ada innovation dan sebagainya, bagaimana urusan intellectual property ini. Jadi ini sudah diusulkan supaya you have to be more for example benevolent towards developed and less developed countries. Tetapi ini hanyalah usul dan masih lagi tidak mendapat umpamanya sokongan daripada negara-negara maju yang tentunya mempunyai banyak multinational companies yang di tempat mereka, ya. So apakah itu? Apa impact trip itu kepada kita, kepada rakyat, kepada consumer, the end user at the end of the day, ya? Kerana rakyat yang akan menanggung apa-apa yang berlaku atas ya, tindakan ataupun action taken by the government. So that is one issue, ya. So WTO sangat terkesan, kita sangat terkesan. We are affected by WTO, not just as regard to intellectual property. It involves trade, yeah, or goods, trade of goods. It involves professional ataupun services, ya. Semuanya we must, kita perlu tahu bahawa pada tahun 1986 apabila Uruguay Round, ya, pusingan Uruguay berlaku di mana WTO ini hendak diperkenalkan, sudah banyak isu-isu lama diketepikan. Isu-isu berkaitan dengan trade on goods. Negara-negara membangun seperti Malaysia, Indonesia masa itu masih lagi kurang memahami, because it is so technical that we don't have specialists in our area to assist or to advise the government on what to do, what are the things that need to be done, ya. Dan ia mengambil masa selama 10 tahun, akhirnya WTO menjadi satu agreement yang sangat penting, ya, perdagangan agreement ataupun perjanjian perdagangan yang sangat penting kepada semua negara. Dan pada ketika itu you have no choice, state have no choice but to accept to become a member or signatory to WTO. We have no choice with all other package. What are the packages? Selain daripada WTO, dia ada TRIPS, ada TRIMS, ada GATT services, government procurement adalah optional. Tetapi kita tidak ada choice. Ya? Semua negara pada ketika itu terpaksa menerima WTO itu sebagai sebahagian daripada kehidupan kita seharian. Jadi sehingga hari ini Indonesia juga menghadapi banyak masalah berkaitan dengan regime ataupun legal regime on WTO or World Trade Organization ini. So itu satu aspek. Keduanya, to what extent does the treaties or convention either control or allow us to achieve what we want? For example, do we have the right to determine the direction of our state once we embrace the treaty? Ya? Sekiranya kita menjadi ahli kepada satu treaty antarabangsa itu atau convention, bolehkah kita menukar ataupun membuat reservation, ya, tentang kita tidak perlukan beberapa peruntukan dan sebagainya. Kebanyakan daripada treaties dan convention ini tidak ada reservation. Kita terpaksa menerima sepenuhnya. And how do law and society relate to? Of course, there are changes that we have to make once our government or the state accept the treaties and convention at the end of the day. And how does the law actually work in the real world? Umpamanya, walaupun ada peruntukan untuk membantu negara-negara kurang maju, membantu negara-negara developing countries and also least developed countries di dalam peruntukan WTO, ya, tetapi realitinya itu tidak berlaku, ya. Itu tidak berlaku. So, umpamanya vaccination, ya, vaccination atau vaksinasi itu perlu diberikan juga kepada negara-negara miskin, tetapi hingga hari ini kebanyakan negara-negara miskin dan negara kurang maju tidak mendapat benefit tersebut, ya. So these are critical questions. And what are the challenges? Now, the whole issue regarding international law is that we are very much, or international law is very much Eurocentric. Eurocentric bermakna tidak ada ruang untuk negara-negara membangun seperti Malaysia, Indonesia untuk membentuk atau shape international law as we want it to be. Yeah? It's impossible. And of course, the idea of international law is to give authority, to make the state very powerful. But as I said, it is very much Western-centric in its nature. Dalam kebanyakan treaties dan convention yang telah kita tanda tangani, yang kita ratify, boleh kita kira berapakah treaties dan convention itu benar-benar membantu ataupun memberikan benefit kepada negara-negara dunia ketiga umpamanya. Ya. Sehingga hari ini kita tidak dapat, we are unable to say with confidence that these are the particular, for example, treaties that helps or give benefit to developing countries or the third world, or even the climate change, yeah, the Paris Agreement, the original idea in the Kyoto Protocol before the signing of the Paris Agreement is where there must be assistance, contribution of developed world, membantu negara-negara membangun di dalam menghadapi cabaran berkaitan dengan climate change. Itulah harapan, itulah sebenarnya cadangan daripada Kyoto Protocol. Tetapi apabila Paris Agreement diterima oleh negara-negara, tidak ada peruntukan yang menyatakan secara terang-terang. Kita mau lihat negara-negara maju umpamanya mengurangkan penggunaan karbon. Tetapi apa yang berlaku dalam Paris Agreement ialah negara sendiri yang akan membuat komitmen itu. Negara-negara sendiri. When you think you want to make the commitment untuk reduce berapa Celsius, berapa degree Celsius dan sebagainya. It is too technical. And coming to that, in international law, the issues are too complex and technical. Sebab itu negara-negara small island umpamanya terpaksa menerima kepakaran daripada NGO untuk membantu mereka. When we talk about, for example, the marine biodiversity in the area beyond national jurisdiction, when we talk about climate change, there are a lot of technical issues, especially scientific issues yang memerlukan kepakaran. It requires pakar-pakar, saintis umpamanya, yang scientific. Tapi negara-negara kurang maju ataupun tidak yang baru, negara-negara membangun tidak mempunyai ramai pakar-pakar sedemikian. Jadi di sinilah sudah ada manipulasi tentang penghayatan undang-undang berkaitan dengan very specific, umpamanya climate change, trade, international criminal law dan sebagainya. Because we don't have those expertise. Itu satu masalah kita. Satu lagi challenge ialah domestication of international law. Apa maksud saya begini? Kalau satu instrumen, treaties atau convention itu meminta umpamanya if you become a signatory to the treaties or convention, you must make sure that these treaties will be domesticated, will be applied at the national level. Rome Statute is one of it. when you become a signatory to Rome Statute of International Criminal Court, ICC, you have to make sure your country will change the law according to the specs or according to the Rome Statute. So how do you go about this? Ini satu masalah yang besar kepada negara-negara yang sedang membangun yang tidak mempunyai kepakaran dalam bidang-bidang tersebut. Siapa yang boleh memberi nasihat kepada pemerintah atau kerajaan berkaitan dengan genocide, crime against humanity, war crimes, crime of aggression dan sebagainya. Kerana negara kita tidak mempunyai pengalaman. When we talk about crimes against humanity, genocide, ini semua sudah berlaku di Eropah. Dulu lagi daripada kita. Dan negara kita di sebelah sini, kecuali beberapa negara jiran, tetapi negara kita bebas daripada genocide, crime against humanity dan crime of aggression. Jadi siapa yang boleh membantu dalam memastikan umpamanya our local laws will be consistent with the Rome Statute. So because once you accept, once you ratify that international treaties or convention, there is a requirement that you have to change, you have to amend your local law. So this of course affect the society at large. It affect your national laws. WTO, apabila kita melihat kepada beberapa umpamanya General Agreement on Trade and Services, the intellectual property, mana yang tidak konsisten dengan WTO dan lain-lain agreement itu, trade agreement itu, we have to amend, we have to change the law because we are the signatory. That is a requirement that we have to change our local laws if it is inconsistent with that treaties or convention. So this is a real challenge for developing countries as a whole. Local custom and culture should be the prime consideration. How do you encourage, how do you promote, for example, your religion? How do you promote that? Because in Malaysia we have Islam is a federal religion, so they have to understand the sensitivity of Islam, for example, because Islam cannot agree on LBGT. So how do you explain? How do you want to make sure that international community, the NGOs on human rights, for example, understand the sensitivity of religion? In fact, there's a big debate on this in Africa, in even Christian majority countries cannot accept LBGT to be part of, because of that they have to change the law, this and that. So how do you change that? Local custom and cultures, these are very important consideration, because if we don't have this consideration, then the law does not reflect the aspiration, does not reflect the local, does not reflect the local society, it does not reflect the country. So this is something that I think we need to understand. We need to know, these changes definitely, if we adopt, suppose if Indonesia embrace the Rome Statute, for example, to what extent it will impact, or what will it be? What will be the implication? What is the big impact on the people, the society at large, for example? So it's very important. So these are the list. Of course, there are other challenges, but I would just list down some of these challenges. Now, you are aware that international law, as I said, is very much a Westphalian. Westphalia. It is based on a peace treaty signed between European countries in the 17th century, in the 1600s. And it empowers the state. What are the things? Number one, the equality of state and non-intervention principle. In other words, you do your own thing within your jurisdiction. So if a country wish to ratify a treaty, for example, it is up to you really. If you do not want to ratify or you do not want to become a state party to an international treaty, it is your right. It is well within the right of Indonesia, for example, not to agree or not to sign any treaty, because what is important is to what extent it will benefit Indonesia. But there is always this international pressure, well, international community that you have to sign. I'm sure as much as Malaysia, I think Indonesia is also under pressure to agree on signing so many of that international human rights treaties, the Rome Statute, especially, so it's really up to. So this is one good factor about international law, that no one can tell you what to do. You will make that call. You have the right to insist or not to agree or to embrace or not to embrace any international treaties or convention. It's your right. The international community can condemn you, can criticize you, but you make that call. It's your call because of the equality of the doctrine of equality of state, the doctrine of state sovereignty and non-intervention principle. No one can say that you should sign this, you should agree, because this is your right as a sovereign state. So if you feel that you are not comfortable, but the point is that you have the right not to or to proceed in signing any treaties or convention. Yeah. So that is one positive aspect of state sovereignty, the concept of state sovereignty. As I said, to what extent, if we agree on signing treaties or convention, to what extent it has benefited or it give benefit to our people. But of course, in reality, the pressure is always there. The pressure to sign international treaties, especially the international human rights laws, is always there. The group will always, pressure the government to agree in signing. But when you talk about law and society, I come back to the issue, the question, to what extent it has given that benefit to the people. Because I think what is important is the society should be the one who shape the direction of the law, not coming from outside. International pressure should dictate, what the law should be and how we should make the law. That is very important. But of course, the reality is another thing. I mean, the pressure is always there that state will have to do something. Now, of course, this is theoretical, the dualism and the monism approach in domestication of international law, because countries like Malaysia, we practice dualism doctrine, which means to say that there is a different level of between international law and municipality law. Unless international law is made local, in other words, you have an act of parliament to enforce. We, for example, if we sign a Rome Statute, and the Rome Statute requires that it has to be domesticated, then the duty of the government is to make sure that an act of parliament to enforce the Rome Statute must be made at the parliament, because it is not automatic. Unlike the monism theory, where the constitution says that once the government embrace or announce international law, it becomes automatic to that country. So United States, for example, where the president announced that they will ratify, for example, the climate change, then it will apply automatically. So that is the monism approach. So even that would have a great impact on the country. Yeah. So if a leader, for example, Biden, for example, President Biden of United States says that we are going to go back and sign the Paris Agreement because President Donald Trump refused, now we want to come back. But even if it is monism or dualism, still, what is the impact of that treaty as far as the society is concerned? Okay. So it is very important that the domestication of international law or nationalizing that international treaty convention at the national level have a great impact on the society. Yeah, because as I said, in Malaysia, we have to change, we have to amend our penal code if we adopt or ratify the Rome Statute. In our penal code, we don't have, for example, a definition of genocide. We don't have a crime definition of crime against humanity or crime against aggression. So we have to incorporate the Rome Statute provisions into our national laws. So that would be quite, for although you can see it is maybe a legislative, but still, the full impact on the society will be definitely there once it is being accepted. Yeah? So is in relation to the Paris Agreement, the WTO, all these have its effect. The latest negotiation is the pandemic treaty, yeah, which I've written this together with the Dean of Dharmadewa University Law Faculty on the global treaty on the pandemic treaty, because the current international health regulation has its flaws, so many problems. So WHO in their assembly, they wanted to have a new treaty as regard to pandemic, as regard to notification, as regard to so many things, because the current international health regulation, unfortunately, is weak in that sense, because it is difficult to enforce. So they wanted to have a new pandemic treaty. So this definitely have effect on us, because we have to look at our national law on health, for example, on how do we manage pandemic, how do we manage COVID-19 during those 2 years. So it does definitely affect us. Yeah, and it's always the case where the superpowers are not wanting to sign, because they know that it will affect their countries. They know that it will affect their society. Until today, for example, United States is not a party to the Rome Statute of International Criminal Court, although it was agreed by Clinton administration, but at the 11th hour, they withdrew. So was, of course, now Paris Agreement is part of US. WTO, for example, there are so many, big countries, India and China, not being a party to the Rome Statute of International Criminal Court. So what benefit does it bring to us, for example, if we sign those treaties or convention? Because if superpowers are not into it, why are we into it? So this is a very crucial question. To what extent it will benefit our society? So if we are going to do that and we have to amend our laws, it may not be beneficial to our society at the end of the day. Why do we sign the treaties and conventions? So it's very important that we look into that. Yeah. So these are the steps. Just a guide, your ratification process. Adoption during the negotiation, diplomatic negotiation, they introduce, it will be adopted. Then signature does not mean that you are already a signatory to it must be ratified, and then there is entry into force. So these are very important process of ratification. Yeah, and these are all explanation which I will not discuss, but it is a lengthy process. That is why any treaties or convention, before it become a treaties or convention, it take many years. Yeah, WTO takes about 10 years finally to agree to be signed at Marrakesh. Yeah, it was well before 1947 when they started the Havana treaties, and later on signed in 1995 in Marrakesh. So it'll take years, at least 10 years. The Rome Statute takes some time. So any treaties, because it affects the state, that is the reason why we have to be very critical. Countries, developing countries especially, have to be very critical. Why do we need to sign certain treaties or convention? Who actually will benefit the treaties or convention at the end of the day? Because until today, there are a lot of criticism against or level on WTO, whether it helps, whether it benefit developing countries at the end of the day, whether it benefit were least developed countries at the end of the day. So again, when we talk about law and society, when we talk about law and development, these are issues that we need to highlight. We need to, consider before that become part of national laws. Yeah, because in Malaysia, we do not have, for example, referendum asking the public, the people, the rakyat, yeah, to whether to agree on the particular treaties or convention, whether Malaysia or the government should sign or not. It goes straight to the parliament, and it then will depend very much on the members of the parliament, the parliamentarian, how they're going to argue the case. And because most of the time we are very much domesticated, we only discuss issues affecting our community, our constituency, our society. We don't look at it at the big picture of why, for example, the treaties need to be signed or ratified by our government. So it is important. Therefore, when you talk about law and development, you have to take international law, treaties or convention as part of the system, because when we talk about law and society, we only look at our domestic. It is more of domestic consumption. We don't go further beyond our shores when it does affect us tremendously. Yeah? The climate change, for example, is one that we have to seriously look upon. And as I said, we don't have people, enough expert to assist us. Complex and technical issues of international treaties. The interpretation of the treaties requires long and complex issues. So one need to understand what are the issues. Yeah, for example, the coming marine biodiversity in area beyond national jurisdiction, or BBNJ they call it. I was made the Malaysia representative in 2016 when that was only a preparatory committee, not government level. So when we went there, we see that there are a lot of bureaucrats, governments, where they are not expert in the area. They may be expert in negotiation, they may be, but not on technical issues. When you talk about marine genetic resources, MGR, for example. So who should advise, the best person to advise us? Because Indonesia is basically a maritime nation. You have 17,000 islands, so you are affected by illegal fishing, so how, for example, who are going to assist you in trying to interpret or the marine biodiversity in the area beyond national. This is not just about the 200 nautical miles or the rights, the maritime rights of Indonesia, but it is something that is beyond your sovereign right as a maritime nation. So it is a very complex issue, because once you sign that agreement, you are affected by it. You then will have to go into your national laws. How does that affect your national laws? How does that affect your community, your fishing community? Because Indonesia, for example, contribute quite a percentage on fish stock. So these are very important agenda. You have to go beyond your shores to ensure that the society will benefit at the end of the day, and they are not affected if there are shortcomings of the treaties or convention. Of course, the second point is the shortage of experts and specialists. We are very much in dire need of experts and specialists to advise the government. Nowadays, the treaties and convention is not classical or the traditional treaties and convention. It is very technical. It is very scientific. If you talk about climate change, for example, if you talk about sustainable development, SDG, for example, the 17 initiative of sustainable development, for example, who are to advise you on water, on ocean, on, all this requires scientists, requires those, input from these very important people. The pandemic, for example, who are the person who can advise you on why or how Indonesia should be, how does Indonesia is affected by the pandemic treaty if agreed upon, at the end of the day. Then there is a need for clarification and how, this is very important, how the treaty affect the state. The state means the society as a whole. Because international law, you cannot see international law as something that is very blurry, that does not affect your country. It does affect your country and my country. So there is a need to have a public forum to discuss the issues. Now, very unfortunate that Malaysia, we don't have much of this public forum being discussed, in the media. Unfortunately, we are very much domesticated. We talk about national interest. When you talk about international interest, it is very much national interest, because we are affected by whatever happened. Ukraine is at war with Russia. We are suffering because of, we don't have enough, for example, cooking oil. We are lucky because we have our palm oil, but countries like Africa that rely not on rice but tepung, flour, they are affected by the war. So who says that you are not affected by what is happening around the world? We are definitely affected. So I think for any treaties and convention, there must be public forum to discuss the issues. You need to talk about, for example, Indonesia despise illegal fishing, for example. Now, how do we ensure that you have that fish stock, that ensure that Indonesia is secured in that sense? So how do you go about it? How are you affected by UNCLOS, for example, the UN Convention on Law of the Seas, as regard to environment, as regard to so many things. And finally, negotiation skills. We must not lose sight of the negotiation skill, because if we don't have the skill, then it's going to be very difficult for our country to ensure that what we want will be be there, guaranteed, and at least developed world will ensure what our grievances, what are our complaints, what are our criticisms. So if you have a diplomat that is not able to use the negotiation skill, then we really have a problem there. So and I know time is running out. So finally, I would say this, that in order to embrace international treaties, state must ensure that as a whole, the society as a whole must benefit when the treaty is implemented. And of course, there is a condition of transparency. The process and full impact of domestication of the treaty must be made transparent to the society. The society must be in the know not only parliamentarian, not only ministers, not only those who are the public at large, the society at large. So then we can talk about law and development. We can talk about law and society. If you don't have this, then how is the law going to be expanded? How the law reflect the need of the society, reflect or give the direction for the state. So I stop there. I'm sure there are a lot of questions. Please do so. Thank you.
Thank you, Professor Dato Rahmat. Very interesting. For me, very interesting because I am a constitutional law expert, which is I don't know much about international law, but I just want to underline in Indonesian Constitution, it says that in Indonesian Constitution, apabila ada perjanjian internasional yang berdampak penting pada masyarakat, maka harus memperoleh persetujuan parlemen, DPR. Only that in our constitution. Jadi Profesor Rahmat sudah memberikan penjelasan yang sangat komprehensif, saya kira, tentang bagaimana dampak dari international law terhadap society, ya, yang tadi digambarkan problemnya sangat kompleks, tidak hanya only negotiation skill, tapi juga tentang clarification on impact to the state. Nah, saya persilahkan sekarang kita masih cukup waktu, mungkin 1 atau 2 respon atau pertanyaan dari partisipan. Please, you may speak in bahasa or English, it is up to you. Oke, saya persilahkan para partisipan, students, and also a public. Silakan. Raise your hand atau langsung saja menyampaikan, ya. Ya, ada Giza, ya. In the chat Pak Profesor Dato Rahmat,
Ya, coba.
ya. In the chat Giza, ya.
Ya.
Oke, can you read it, Pak Rahmat, Profesor Rahmat?
Dalam konteks hukum, itu kan soalannya?
Ya, dalam konteks hukum dan masyarakat, ya, bagaimana cara Malaysia merespon hukum internasional yang pada pokoknya berpengaruh bagi Malaysia dan masyarakat Malaysia. Tadi Prof. Rahmat mencontohkan HAKI, LGBT, and etc. ya. Bagaimana di Malaysia menerapkan metode untuk merespon hal ini di Malaysia, ya. First from Pak Giza, second Pak Afan, silahkan langsung, nanti akan direspon oleh Prof. Rahmat. Afan, silahkan, please.
Afan.
Oh, your student, I think.
Yeah.
Yeah, I remember that. Yeah, Afan, please. You still mute, Afan?
Mute, yes.
Host, please unmute Afan. Host, please unmute Afan. Okay, please.
Thank you, Pak Radian, Prof. Dato Rahmat. Assalamualaikum. Good evening or good afternoon for all of the participants. Glad to meet you again, even virtually, Prof. Rahmat and also Pak Radian and ladies and gentlemen. So my question is actually, I've read that this is a little bit out of topic, but I hope this is not too far-fetched, because the one thing that I would ask to Prof. Rahmat is related to a discourse in international law, which I think recently got many attention from the international community, which is the air and space law. So we are beginning to see that the development of space and air law or businesses in this world tend to be led by private or non-state actors. Let's say Elon Musk with his SpaceX, and then Starlink, which aim to provide a satellite which may provide a fast connection internet for the public. So I believe that in the end, even though air law and space law is not our daily or our conversation on daily basis, but I think still it will affect the society in the end. So how do you see, or how the international law perspective sees this kind of development where private sector could it be said or categorized as non-state actors, which drive the development of that aspect? Maybe in the future it is not only just air and space. Perhaps what you have just mentioned regarding the decarbonization or the climate crisis. Maybe one day, because of people are seeing that states are not that effective and efficiently overcoming this issue, then perhaps 1 or 2 billionaires create their own business to tackle this problem. So how does the international law respond to this kind of trends? So I believe maybe this is not directly related to a certain treaty, international agreements or covenants, but I'm curious on your view. How do we best to analyze and also to actually discuss this kind of development? Thank you, Prof.
Thank you, Afan. I think that is a very good question.
Yeah.
I think, the 300 years old of Westphalian international law, unfortunately, only recognize state as the key player in international law. But we know very well that now negotiations of international treaties and convention are being led by NGOs, by scientists, individuals. So I think there is a room for NGO, non-state actors, to be effectively be given that stature, because currently we only have international organization and state as the having that that characteristic or the players, the key players of international law. I think that there is definitely, if you read, there are a lot of literatures now being written. What about NGOs? What about non-state actors? Should they be given that status? I think it's about time that individual and non-state actors, NGO, be given that status under international law. That we call it a privy to any international treaties or convention to be, this. Having said that, the European Court of Justice recognized individual, not just the state, as an entity to international law. So I think there is already a precedent set, and I like the idea that individual therefore can contribute to the progressive development of international law. But I'm not sure about Elon Musk, because he is a billionaire. He makes a lot of money. There's always this question of sincerity, how, to what extent, there's already been talk by a very leading billionaire on COVID-19 pandemic well before the pandemic, So that kind of is a concern. I'm very concerned because at the end of the day, the people are very much affected by multinational companies, by individuals who makes money. It's not that I'm against it, but if it is for the benefit of the people as a whole, if it is for humanity, why not? But then there is the extent of to what Elon Musk talk a lot of things. The space and the of course, this is something, one area that not all countries are able to participate actively when they talk about space law, when they talk about satellites, so on and so forth. Again, these are very much exclusively the rich countries or individual will be very much involved in this. But I think the idea that private sectors, non-state actors should should be given recognition. I think it's about time that international law will have to open its horizon, not just state and international organization. I think there is a lot of promotion on NGO being part of international law, so individual too. So Afan, I think that is my take on your question.
Thank you. Professor Ahmad, you may respond written question from Giza. So the point is want to know the practice in Malaysia, terutama apabila ada international treaty, itu bagaimana respon publik? Apakah di Malaysia pemerintah menyampaikan secara terbuka sehingga ada public discourse, public discussion, atau seperti apa? Kalau di Indonesia, saya yang merasakannya, perjanjian internasional apa yang terjadi dengan pemerintah dan international treaty body tidak terlalu banyak terinfo kepada publik. Ya, how about Malaysia about that?
Sama saja di Malaysia, Doktor, ya. Sangat kurang perbincangan, perdebatan tentang sama ada Malaysia seharusnya menjadi ahli kepada beberapa treaty dan convention. Sehingga kan kita meletakkan kepercayaan kepada beberapa individu ataupun peguam yang mengaku mereka itu pakar, sebenarnya mereka itu bukan pakar. Ya, ini yang berlaku di dalam Rome Statute. Saya disalahkan sebagai orang yang tidak yang anti Rome Statute. Sebenarnya bukan begitu. Tidak ada satu manusia pun, no human being would agree on genocide or crime against humanity, pembunuhan beramai-ramai. So my objection when the government ratified Rome Statute was that the process was not observed. The process was not observed. There's not enough discussions. The discussion was only at the level of bureaucrats. Why? Because this affect everybody. This affect the people. This affect the rakyat. So I was. If you look at you can Google my name and just put Rome Statute. You will see a lot of attack on me. Attack on me and my team. Because there are only 4 of us. The other issue that we are concerned is the position of our king. Because our king is a 5-star general. He is the supreme commander of the army. And there is no exception under the Rome Statute that the head of state, is our king, can be prosecuted. There is no exemption. There is no, they call it impunity. Of course, we don't expect our king to be prosecuted, but the point is that they should be consulted. We have a conference of rulers that they should. So that was my objection. But at that time, I was attacked as anti-Rome Statute, anti-government, this and that. So actually, they misunderstood the whole thing. So why this happened? Because there was not much discussion. There was no deliberation. There was no debate. There was, it's only a discussion, among parliamentarians, but not all parliamentarians are expert in Rome Statute, in international criminal law. I think so I thought that the academic will have to play that role. The public intellectuals will have to play that role, at least to advise the government on whether they should become a party or not. After considering all the issues or the condition that we have spelled out. So I think why I say this, because why I put all that, because it happened to me. I experienced it, It was a 1 month horror or nightmare that I can't sleep, because there was a strong cyber attack, cyber bully on me, And the worst part is to say that I am a, Professor Kangkong. You know what is Kangkong? Worst professor. So I cannot accept that. I worked in Asian African Legal Consultative Organization for 8 years to advise government on Rome Statute. How can I be a, a person who has no knowledge of the law. But I know that lawyers think that they know the law, but they know nothing about, because as I said, international law is very complex and very, it need to be explained. So that is my answer. I think we need more discussion. We need to have a public, not lecture, but public debate. We have to open this because it affects the rakyat at the end of the day. So why do we talk about law and society when the society are not given that opportunity to be given that opportunity to give their view on whether we should or we should not be part of that international treaties or convention. So that is my take. Thank you, Dr.
Okay, thank you, Professor Dato' Rahmat. One question, short question from me.
Sure.
Apakah citizen Malaysia has standing to petition for judicial review for ratified international treaty by the state in Malaysia?
Okay, there should be a provision, on judicial review, but judicial review has its limitation, What sort of judicial review can be entertained by the judiciary? This is the issue also. So not all issues can be, subjected to judicial review. The limitation of judicial review is this: it is only when you go to court you will know the outcome of that, the issues. Otherwise you wouldn't know. Of course, you have to go to court, but to what extent? But because the court can always say this is a non-justiciable issue, we cannot decide on this. It's not beyond us, so on. So it is beyond us. It's not within our jurisdiction, so on and so forth. So that is the limitation of judicial review, Dr. Radian, in Malaysia.
Okay, thank you, Professor Dato' Rahmat Muhammad. All participants, I think. We finish now, the time 5:15. So kami ucapkan terima kasih yang agung kepada Profesor Dato' Rahmat Muhammad. And next time we still have some agenda, I think, for giving a lecture as a visiting lecturer at postgraduate school. So today, once more, I would like to say thank you. Please, Professor Dato', you may deliver your closing statement.
Thank you, Dr. Radian. Sebenarnya saya kepingin sangat nak ke Airlangga ketemu dengan postgraduate dan rakan-rakan. So I hope when the borders is open, things are easy. I think we can make it to Airlangga. I look forward to meet all of you in Airlangga. And please, anytime you need my help or any contribution that I should make, please do so. As regard to postgraduate, apa yang hendak bercadang untuk membuat PhD, saya boleh bantu dari segi memberikan nasihat dan pandangan saya. Saya ada satu pelajar dari Indonesia, PhD student saya. I will not tell you his name because he's a celebrity. So he is my PhD student at the moment. So thank you so much, Postgrad School, Syafia, Dr. Radian, kerana menjemput saya untuk memberikan syarahan ini. Terima kasih. Dan selamat hari raya lagi. Salam Idul Fitri.
Selamat Idul Fitri juga. Safira, please, you may close this forum. Thank you.
Thank you, Dr. Radian Salman, for moderating us today. And thank you, Professor Dr. Ahmad. It was very interesting and we're very delighted of it. And can wait for your attend in person at Airlangga University. And thank you everyone for joining us today. I hope this guest lecture will be giving you all a new knowledge and understanding. Okay, thank you, Professor Ahmad.
Thank you. Assalamualaikum.
Waalaikumsalam.